here in Ghana is different.
In March of 2012, I took 11 law students to Ghana for a spring break trip to study women's property rights, which is an issue that's now pending in the Ghanaian parliament and an issue that's very much before the courts.
Throughout law school, we spend a lot of time learning about human rights and a lot about the inability of international law to adequately protect human rights. But this seemed like a way to look at how you might be able to secure human rights for certain groups through domestic legislation rather than international law.
Ghana has a constitution that's based on the U.S. Constitution, but it's much more detailed than ours and actually has a provision in it that says that Parliament shall enact laws that will provide for equal spousal property rights. But they also have a very strong customary law system, which is derived from tribal law and is treated as part of Ghana's common law under its constitution. And the intersection of the common law court system, the constitutional provisions, the statutory system they have, and customary law make for a very interesting mix.
The Property Rights of Spouses Bill, one, helps women in cases of divorce or death. It allocates property rights to them. One of the issues in Ghana and in Africa in general is that there are different forms of marriage. Customary, Mohammedans, and in Ghana, the ordinance marriage.
In the weeks leading up to the trip, we had a very intense reading course in Ghanaian law, looking at the culture and religion of Ghana, at Ghana's forms of marriage, looking at the status of women's property rights generally, intestate succession law as it now exists under the current law, and then at the bills that are pending before Parliament.
Getting an understanding of the traditional perspectives and the religious perspectives and how the two coincide to either help make the law more accessible or collude to make it more difficult to access was my contribution to the class.
One thing I really learned that I can carry forward is that studying these bills in Durham before we left, there were certain aspects that we just found as a class confusing and thought didn't really make sense. And it was because we were viewing it through our cultural lens, through the idea that marriage is a partnership, for example. And so when we were there, very politely, the Ghanaians would remind us sometimes, well, we have a different cultural sense and that's why we treat this differently. So it wasn't, I feel like I did learn more about Ghanaian law and the legal system, but it was in context. And I think I hadn't given the proper emphasis and significance to the context until I was there.
From some of our very first meetings, we met people who had been working on this issue, for over a decade. So it was humbling. We recognized that we needed to check ourselves. We'd only been reading about this for the past couple of months, and we really needed to try to soak in all of the knowledge that they had from their past experiences, both with this bill and their previous successes advocating for other social change legislation.
We got a good perspective on the ground with NGOs, with the parliamentarians, with the courts, with the academicians, and I think that's given the students a very good overall picture of how these issues play out from a variety of perspectives.
As future lawyers, we're supposed to be advocates. You can't advocate for someone if you don't really understand their goal and their purpose. And so that was something big that I took away from this trip.
I'm a 3L and I'm about to graduate, and I felt very re-inspired by the public interest attorneys I met there. The female civil rights attorneys we met there just worked with an incredible sense of urgency, energy, professionalism, and they were making a lot happen with not a lot of resources, so they were kind of redefining what's possible. I feel really grateful that I got to meet with them and speak with them.